Hello, everybody. Wanted to take just a little bit of time to talk about subpoenas and search warrants and court orders when it comes to seizing digital evidence. It's come up in class a few times, so I thought I could dig in just a little bit deeper on that. So what we're hoping to accomplish, we're going to talk a bit about the Fourth Amendment. I know we've talked about it in class. We'll talk about it some more. We'll talk about how the courts address Fourth Amendment violations. We refer to that as the exclusionary rule. We'll talk about some of the requirements of a valid search warrant. We're actually going to go through the stages of developing probable cause, which is one of those elements. We're going to talk about some of the exceptions to a search warrant. So when we can search without a warrant, we'll talk about grand jury subpoenas, and then some of the other ways that we can request information or seize digital information via administrative subpoenas, administrative warrants, court orders. So that's kind of what we have on tap for today. So we start everything when we talk about seizures with looking back to the Fourth Amendment. So the Fourth Amendment of the Constitution is all about privacy, right? So the right of the people to be secure in their persons, their houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. So the Constitution is very, very specific that in order to conduct a search or a seizure of someone's property, we must have a search warrant. This comes up a lot in these public sector investigations, right? So at what point does law enforcement, does the government, what can you view, what can you use, what's admissible in court? And we refer to all of these as kind of Fourth Amendment violations. So the solution to an illegal search or a seizure is something referred to as the exclusionary rule. And so the exclusionary rule was kind of developed back in 1886, so a long time ago, in Boyd versus the United States. And so the federal officials seized 35 cases of plate glass that were being brought in through the Port of New York. And so the reason they seized them is they said this individual, Boyd, was trying to bring trade goods in without paying import fees, without paying taxes on them, basically. So this is kind of where it came from. The case goes all the way up through the Supreme Court. The Supreme Court says that a search and a seizure is the same as forcing someone to give up their private papers. So they said, even though this was stuff, it's the same as private papers, which are protected by the Constitution. Therefore, this was an unreasonable search and seizure because there was no warrant, and the evidence, the items seized, had to be thrown out of the court hearing. And so at that point, obviously, the federal government couldn't make their case. And so for a long time, the exclusionary rule only kind of applied to federal. In 1914, there was a case called Weeks versus United States. And so basically, it kind of came back and said, look, the exclusionary rule applies to federal courts, but just because it's a federal prohibition, they called this the silver platter, you can't get local officials, you can't get state law enforcement to go do an illegal seizure, seize a bunch of evidence, and then give it to the federal agencies for prosecution, right? And so that's also prohibited. So that's from 1914. 1961 was the next time this comes up. And so there's a case called Mapp versus Ohio. And so there was a case where an individual was being sought. There was an arrest warrant out for him. Ogletree is the name, that's his picture there on the side. So he was being sought in conjunction with a potential bombing of a rival. He was into illicit gambling and that. And so during the illegal search of Virginia Mapp's apartment, so there was a downstairs rental, they found him hiding, and in that they also found pornographic magazines. MAP said, hey, those are not mine. That's a previous tenant, left those behind. Ogletree's conviction winds up getting thrown out because they couldn't make the case against him. He was exonerated in this bombing attempt. So the state officials turned around and prosecuted MAP for possession of pornographic materials. Again, this is 1961. Now it's all over the internet, not a big deal, but in 1961, this was a big thing. And they were going to sentence her to 1 to 7 years in prison for having pornographic magazines in her possession, not exploitation materials, just regular run-of-the-mill, we would say now, pornography. So the reason they launched this prosecution is she would not testify against the rival of Ogletree, which was this guy, Don King. And so Don King supported her, and she refused to testify against him in some proceedings. And again, the case goes all the way up to the Supreme Court. Supreme Court says, hey, not only does this exclusionary rule apply to federal prosecutors, and you can't use state agencies to illegally grab evidence and then use it in a federal prosecution, but the exclusionary rule applies to all courts. And so this basically promulgated is the legal term, right? So it forced that exclusionary rule down into lower level courts. Another kind of an important case for us is silverthorn lumber. And so it's the fruit of a poisonous tree. And so you'll hear as we go through class, we may talk about this a few times. So not only can you not use the illegally seized evidence, you can't use other evidence, even if it's lawfully seized, if you used illegally seized information to develop, right, to locate the other. So this, if it starts with an illegal search, everything that comes after that would also be illegal. So a few cases that limited the exclusionary rule. So Bordeaux and McDowell said that evidence unlawfully obtained from a private person is admissible. And so this case still comes up today for digital forensics or for hacking type investigations. What happens if a hacker discovers evidence of illegal materials on a server, and they send that even anonymously into law enforcement? Is that actionable? Can it be used? And according to Bordeaux McDowell, yes, it can, because they weren't operating at the direction of law enforcement. US v. Jeffers, evidence can only be suppressed if that person's Fourth Amendment was violated. So you can't claim a Fourth Amendment violation for a third party. You can't also, generally speaking, the courts have kind of said, look, you can't just take advantage of a loophole if the police were acting in good faith. If they thought they had a good warrant and there was something wrong, it gave the wrong address, or the color of the house was wrong, or something like that, you can't exclude it from that. That's the courts aren't going to allow that. And then the Nix versus Williams sort of restrained a little bit of that fruit of the poisonous tree and said, if police would eventually have found that information anyway, then that still would be admissible. So there's a lot of case law, a lot of precedents about when evidence cannot be used in court. And this is very important for our public sector investigations and forensics. So if there's exceptions and there's restrictions on that, do we really need to obtain a warrant, right? Is it really, should we obtain a warrant? And the answer to that is absolutely. So whenever, and particularly in digital evidence, law enforcement should seek a search warrant. Case law, state law, we're in Texas, is pretty clear that a warrantless search is presumed to be unreasonable by the court. So if you conduct a warrantless search, it's deemed to be unreasonable. The prosecutor has to prove to the court we meet one of these few exceptions that there are, and so we should be able to use this evidence anyway. And so the first reason would be, why go through that hassle? most digital evidence, it's not like it's going to evaporate, or if I don't look at it right this moment, right, there are ways for us to preserve it. And so really we should force law enforcement to use search warrants whenever we're talking about seizing digital evidence. So, without a search warrant, you're just as likely to spend more time in courts arguing about if the search was valid over arguing what the evidence actually showed. So there are three basic components to the search warrant. So the Fourth Amendment talks about. So there's that affidavit. And so the affidavit supported by oath or affirmation, that's, that's I swear. You don't have to put your hand on a Bible anymore, but you still, law enforcement, you still raise your hand, you still swear to the judge that that's true, and then you sign off. And so that your affidavit details the probable cause. Here's the reason we think this this whatever location contains evidence of this crime. And so there's the warrant itself, and so that's what the judge signs, that directs law enforcement or a person to go and seize or search this particular place and seize these things that are particularly listed. And then there's a return. And so search warrants expire, basically. So a search warrant is generally valid for 3 days from the time that the judge grants it, 3 full days. There is an exception for that we take advantage of in digital forensics, digital evidence, because it takes a little bit more to deal with that, right? It's not like walking into a house and looking through drawers, right? It's a little bit more involved. And so digital evidence, electronic records generally were given, there's a 14-day extension, if you will. So you've got up to 14 days to complete that warrant. Some jurisdictions do not allow 14 days. They give only 3 days. And then at the end of that 3 days, just California, Ninth Circuit is an example of this. They require law enforcement to destroy any evidence. You've got 3 days to look at it. And at the end of the 3 days, if you don't find something worth keeping, you destroy everything, or you destroy everything but what you're keeping. And so that's a pretty tough bar sometimes for law enforcement out there. So we talked about what it takes to get the warrant, right? So how do I get that? What is probable cause, right? When this is I need this affidavit that details out probable cause. What is that? And so there's kind of a continuum, if you will, of evidence. And so it starts off with reasonable suspicion, right? There's no evidence. Something's not really quite right. And so we're limited into what we can do. Then, so beyond that, we refer to that as a mere suspicion, right? So first, you got nothing. Secondly, as well, mere suspicion. I'm starting to say, you know what, something really isn't right based upon my training and experience and the things that are going on. I'm saying this is not right. Then I have a reasonable suspicion. So, right, we're escalating and what? So reasonable suspicion, I'm starting to go, you know what, this is really, there is something here and it's worth looking at. Probable cause is the next level. So probable cause is where you can detail out very specifics that why we believe this place, this person committed a crime, and this is why we would find evidence, or we believe we'll find evidence of that crime in that. There's a couple of, when we talk about prosecution, right? So the next level of proof, if you will, would be a preponderance of evidence. This is the standard used in administrative courts. And so a preponderance of the evidence means, more likely than not, right, this is evidence that this person violated some statute, generally administrative. And then we have the proof beyond a reasonable doubt, right? So that's that evidence when in a criminal case, we're pretty familiar with that, or hopefully you are, right? That for us to convict someone in a criminal court, I should say allegedly, in the United States, right, we need proof beyond a reasonable doubt. So if the defense can show, hey, there's reason to doubt this might not be true, we're supposed to find that person innocent under our legal system. And then there would be the 100% certainty. That's a very high bar, short of law enforcement watch someone commit the crime. And then still there would be arguments that would around that. So that's a pretty high mark there. So suspicion, right? The legal definition, that act of suspecting or being suspected, imagination, generally something ill, distrust, mistrust, apprehensive something without proof, right? Or upon slight evidence, that's suspicion, right? So suspicion is that I believe, I think, like based upon the circumstances, this isn't quite right. So it's kind of that, that kind of looks like a duck to me, right? So that's suspicion. If I have that mere suspicion, right, what can we do at that point? We can continue to search. We can continue to observe. I shouldn't say search, right? We can continue to observe our suspect, observe behavior. You can do computer checks, right? So background checks, criminal history checks. For law enforcement, you can run the license plate of the car because you're thinking something's not quite right of that, right? Verify insurance status, those things. You can approach a suspect and ask questions, right? If you're in an area that has lots of burglaries at night and you see somebody standing there with a backpack, looking in a window, hey, that's kind of suspicious. You can stop and say, hey, why are you looking in the window of this business? That is perfectly acceptable. And then reasonable suspicion. So it's not quite probable cause. So this is the legal standard for arrests, right? Reasonable suspicion, right? More than just some hunch, right? You need some sort of specific and you need to be able to detail out those facts, taking the whole situation together, right? And saying, back to somebody looking into windows, right, in the middle of the night of a business. There's been lots of business thing, and in the backpack they've got crowbars and sledgehammers and things like that. Oh, you know what? That's pretty suspicious behavior, right? So, would a reasonable person, right? It's a lot of that standard reasonable person or a reasonable officer, it's law enforcement, right? Would they, in the same circumstances, interacting with the same suspect, would they feel that same way? So that's reasonable suspicion. So you know what? It looks like a duck. It floats like a duck. Still, I'm not totally sure, right? So we have some legal precedents that helps us determine kind of those things. And so the United States v. Cortez talks about the whole picture must be taken into account, and the evidence collected must be weighed as understood by those in the field of law enforcement. So think about that for us and in the forensics field, right? We understand computers and how they work and how they store information way better than 12 random people off of the street, right? 12 senior citizens that went, hey, sure, I'd love to, serving on a jury, it's my patriotic duty. They probably don't have the same level of expertise that we have, right? And so that case kind of says, you know what, law enforcement, for us, right, forensics people, we receive training. We go through coursework. We go through exercises. We develop those skills and to be able to deduce, to be able to interpret the facts and understand more of what they mean. And so that's the court case that sort of went that. So probable cause, right? So sufficient reason based upon the known facts to believe that a crime has been committed and that certain property is connected with a crime. So you know what, at this point, it looks like a duck, it floats like a duck. You know what, that's a duck. I've seen ducks before, that is a duck, based upon my training and experience, right? So this is how we go through that process, sort of mentally, of developing these probable cause statements. So we talked about limits to the exclusionary rule, right? If we violate a Fourth Amendment, someone's Fourth Amendment, right, that evidence can get thrown out, but do we really need a search warrant? Because we know there's some restrictions, right? Good faith and some others. There's a few really well-known exceptions, or we should say court precedents there. So searches incident to arrest, right? Somebody's being arrested, you can search in their immediate area of control. We refer to that as a wingspan. Right. So if you're arresting someone, you can look in their backpack if it's at their feet. If you're arresting them and they're in the living room, you cannot go to the back room and start digging through a closet, right? Not within their immediate control. Plain view is used a lot in law enforcement, right? So the officers go in, they might be arresting, they might just be there to talk to someone. They look down and like, hey, look, there's stacks of cash and baggies of white powder, and gee, that could be evidence, right? So that's plain view, or in a vehicle, right? So plain view, plain smell, burning marijuana or paraphernalia laying around inside the car. Those are all plain view. Plain view generally not accepted at all for digital evidence. Just don't think that's not an out for not getting the warrant there. So during a stop and frisk, we're not that probably familiar with it. Down here is a big more up north. There's a lot of controversy around stop and frisk. So if a person is in a suspicious person in a suspicious place, circumstances, right, an officer can pat down their outer clothing and say, hey, I want to make sure this guy is not carrying a gun, right? So that's an exception to warrant requirements. Automobiles, because they're movable, right? I can't just, now you wait right here on the side of the road, I'm going to go spend 4 hours to get a search warrant and I'll be right back, right? Probably bad guys aren't going to do that. During an administrative inventory, there's no requirement for to get a search warrant. We refer to sometimes as exigent or hot pursuit. So exigent circumstances or hot pursuit, someone's life's in jeopardy, police are actually chasing someone into a building. They get there, like normally they wouldn't be able to run into the building and look around, but now they can because they're searching for someone, they're in hot pursuit, right? So that kind of works with plain view. And really, for our standpoint, consent is the only time we really don't need a warrant when we talk about digital evidence and digital forensics. So consent is the only one that we can pretty confidently say, you know what, I'm not going to worry about whatever I find being thrown out in a court case. If I had consent, it has to be what's termed as valid consent. So the person consenting has to own the device. So the manager of a business, the owner of a business, if it's a business computer, they can give consent, right, for all of the business's computers to be searched. This becomes an issue in network intrusion investigations sometimes. So how much consent, or will the business even offer consent or give consent? Because businesses, unfortunately, are afraid of being sued. And so they don't want to give consent to law enforcement to search, and then something bad is found and one of their employees gets arrested for doing something horrible, and then they get sued because they allowed law enforcement to search. So there's a lot of cases that have filtered through and that as well. So the bottom line to all of that, in digital forensics, if we're going to seize digital evidence, we really should have a search warrant. There's a few other ways we can get information, or some information. Court orders are one, and the other is subpoenas. So there are administrative subpoenas where they can be issued by a regulatory entity. So in breach notification cases, right? So companies, if they have federal regulators or state regulators, or even a regulatory body, probably not so much, but federal and state regulators, they can issue a subpoena and say, hey, we want to see these documents. We want to see what you did and how you handled this event. The legal term is a subpoena ducis tecum or tecum. And so that's a bring the documents before the court. So there are administrative subpoenas for public sector investigations, right? We move over to the Fifth Amendment. So the Fifth Amendment, right? So no person shall be held answerable to a capital, otherwise infamous crime unless on presentment of an indictment of a grand jury. And so the Fifth Amendment, along with the right not to incriminate yourself, right, and due process, says for for felony offenses, we need to have an indictment from a grand jury. So every county in the United States has a grand jury. The number of people sitting on that kind of varies, but basically this is a chance for law enforcement to go in and say, hey, we're conducting a lawful investigation and we need these documents, or we want to look further into this. We believe a crime has been committed. And so that is how we request a grand jury subpoena. So it's issued by the foreman of the grand jury, or a district attorney can sign it as well. It's only requested by peace officers. Businesses or entities are given a minimum of 10 working days to comply. You do not have to say it's that. So unlike a search warrant where I have to say, this person we believe committed this crime, and here's the evidence I'm looking for, and I believe it's going to be in this place. This is a much more vague, right? I can say, I just want to see these. I have an IP address. I want to know who leased that IP address. Who's the account holder that owns this telephone number? Those are information that we can gather with subpoenas, grand jury subpoenas. Grand juries proceedings by law are secret. And so the target of that subpoena should never be notified. If that ever were to come up, there's some weirdness out again, California, Ninth Circuit. They've kind of tried to say, well, it depends, and not really, not with a grand jury, it doesn't. Because the proceedings themselves are secret, that means that any documents that are provided under a subpoena cannot be disclosed to anyone outside of use in a criminal prosecution. So documents seized in part of a grand jury subpoena, and then prosecutors say, well, there's really not enough for a criminal prosecution. Maybe they can file a wrongful death, or maybe they can file some sort of lawsuit against them. Here's the stuff we found. That's illegal. It's against the law, right? They have to get their own things. So hopefully that does a good job of summing up some of the search warrants and how we get them and why we get them, why we need them. Fourth Amendment protections. It's going to come up a lot in class. And look forward to seeing you all again next week.